Good afternoon, ladies and gentlemen, and thank you for waiting. Welcome to the American Foundation for Equal Rights press conference call on Monday's hearing in Perry v. Brown. All lines have been placed on listen-only mode, and the floor will be open for your questions and comments following the presentation. Without further ado, it is my pleasure to turn the floor over to your host, the founder and the president of the Board of Directors for the American Foundation for Equal Rights, Mr. Chad Griffin. Mr. Griffin, the floor is yours.
Thank you, operator, and thanks to all of you for joining today's call. This is something, as you know, we do before all of our hearings, and many of you had requested it for this hearing that we're going into on Monday. So thanks to all of you for your time. I'm going to introduce our two lawyers, and then they'll speak briefly, and we'll turn it over for questions and take about 20 minutes of questions. And then if there are follow-ups beyond that or lengthier questions, I know some of you are working on lengthier pieces, if we can just wait till post-call, and then we'll set you up with any of those on the team that you need to speak with more at length for those of you who are doing lengthier pieces. Just briefly, as we go into what has been, I think, resoundingly criticized by most every news organization, editorial board, and legal scholar in the country. This hearing on Monday that is a sideshow, and some have even called a PR stunt by the anti-marriage forces. We, as you know, take every hearing seriously, and we'll be there in court, and we'll handle this issue accordingly. But to just set the stage, I think all of you know that this coming Sunday, the eve of going in to this hearing before Judge Ware, is the anniversary of the all-important case, Loving v. Virginia, and a case that Judge Walker's 134-page ruling cite on numerous occasions, and is something that has been a decision that's obviously quite historic and impactful in our nation's history, and something that is incredibly important as to the context of the decision in the Prop 8 case. Just one other note that we've made on other calls as we go into this hearing. We're less than a year, hasn't even been a year since we achieved victory in the Perry v. at the time Schwarzenegger, now Brown case. That decision came down in August, so it's only been 9 months since we won, and in that short period of time, we had our victory. We've been heard before the Ninth Circuit Court of Appeals. We have taken a very brief delay to the California Supreme Court here in a couple of months on a very simple and direct question as it relates to proponents of ballot measures, and expect that to be heard in September, and then are optimistic about a very quick and timely decision there, and within months being able to move this case quickly to the next step, and very quickly erase Prop 8 from the books finally and forever, so that every single citizen in the state of California will have full federal marriage equality. With that, I want to turn this call over to Ted Olson and Ted Boutrous, two people that need no introduction. All of you have talked to them and met with them and seen them in the courtroom, and these two attorneys obviously are from Gibson, Dunn & Crutcher, and are our lead attorneys in the case. Mr. Boys could not join this morning's call due to another court conflict, but with that, I will turn it over to Ted and Ted.
This is Ted Olson. I will speak first, and I know my colleague Ted Boutrous has a number of things that he wanted to mention. This is indeed 10 months after the judge issued a 134-page comprehensive opinion declaring that Proposition 8 violated the United States Constitution, Equal Protection Clause, and the Due Process Clause of the same Constitution. 10 months later, we are tied up temporarily with the appellate process, but it was an overwhelming, comprehensive victory in which the judge listened to evidence during a 12-day trial. Every witness was put on during the case that either side wanted to put on. We assembled 9 expert witnesses that testified about all of the issues that were raised by Proposition 8, and the judge thoroughly analyzed and responded to each of them. 10 months later, our opponents have decided that they wish to challenged the decision itself, not on the merits, but on the judge's on the grounds of this judge's sexual orientation. That is going to be heard on Monday. I can't be there because all of a sudden the second United States Court of Appeals for the Second Circuit scheduled a hearing in a very important case, so that I will not be able to be in California, but Ted Boutros will be there. I did want to say a couple of things about it and answer any questions. It is quite outrageous for this decision, for our opponents to make this motion. It is, in my judgment, a frivolous, demeaning motion that reflects a desire to distract from the real issues, to talk about anything but the issues. And on that subject, they're also seeking to have the video of the trial permanently removed from any access from the public. So our opponents don't want the American people to see what happened during this trial. There's no conceivable remaining reason why the American people cannot see a serious trial on a constitutional question affecting literally millions of Americans. We very strongly urge that video be made public, and we think every member of the press and every member of the public will want to and should see that and decide for themselves the merits of this case. Our opponents obviously don't want to do that, and they're making this motion to disqualify Judge Walker from having heard the case on the grounds of his sexual orientation, which to me is the same thing as moving to prevent a federal judge appointed by the president, confirmed by the Senate, having served in office for 25 or so years, the chief judge of the Northern District of California there. If it had been a Hispanic judge, they would say he couldn't rule on an immigration matter. If a judge was a racial minority, they'd be saying that he couldn't rule on a school busing or integration case or an affirmative action case. There are 6 Catholic members of the United States Supreme Court. I expect that they would be making a motion to prevent those justices from ruling on death penalty or abortion cases. A disabled person ruling on an Americans with Disability case, a veteran not being able to participate in a case involving veterans' rights. We expect and fully are entitled to the competent consideration by respected federal judges, and for this judge to be assaulted on the grounds of a sexual orientation, and the frivolousness of the motion is underscored by the fact that they made the argument during this case that Proposition 8 was hurting heterosexuals and hurting heterosexual marriage, and so they would presumably be attacking a judge who was a heterosexual judge from hearing the case. The point is, I guess, and I should turn this over to Ted Boutros, that it's a very, very unfortunate motion. It doesn't have anything to do with the merits. The merits they do not want to talk about, and they do not want the American public to know about the trial. They want the American public to know about things that have nothing to do with the merits of this case, and we fully expect that their motion will be treated accordingly on Monday.
This is Ted Boutros. I'll just add a couple of notes, and then we can open it up to questions. To me, what is really striking about this motion is that the proponents of Proposition 8 made the pretense throughout the case that they were taking the high road here, and many of you who covered the trial remember them saying, the fact that they were defending Proposition 8 didn't mean that they bore any animus toward gay men and lesbians. They tried mightily to hit that theme, and I think what happened here is that as they saw their case cratering, both after they failed during the trial to put on any evidence, credible or otherwise, to support their positions, as they saw the difficulties that they have with standing, they become increasingly desperate, and at some point they said, it's time to take the low road. We tried the high road, that didn't work. I don't even think they really did try the high road, but they decided in a last gasp, desperate attempt here to take the low road. And it's offensive, it's outrageous, it's really offensive to the federal judiciary as a whole, I think. But what's particularly grievous, I think, is that the proponents themselves have known for many, many, many months, over a year, the judge's sexual orientation. They declared, as to some of you probably who were on the phone, that this was not an issue they were going to raise in the case. One of their lawyers said back in August of 2010 that this is an issue that collectively as a legal team they decided they were not going to raise. They were going to focus on the legal issues. So I think that really lays bare the fact that this is a desperate ploy, a publicity stunt that has nothing to do with the law. There's not a single case in American history that supports their position. And I think the argument they make that, well, they didn't know for sure what the judge's sexual orientation was until he gave an interview after he stepped down from the bench is particularly weak. But if this, I think the judge deserves to know when the proponents of Proposition 8 knew this fact that they claim is so important. I bet you if we had discovery from them, we would find out they knew from the very beginning. This was not a secret. So this is all frivolous and meant to distract from, again, the utter weakness of their case in this matter. And again, just to pick up on what Ted Olson said towards the end there, the fact that they are acting like the videotape of the trial is some state secret that has to be protected because the world will come to an end if the public sees it is absurd. That was an open public trial, and I think it proves the point. They're trying to argue that somehow they were treated unfairly during the trial. If anyone watched the videotape of that trial, they would see that the proponents were treated more than fairly. The judge was meticulous in how he let both sides be heard, put on the evidence, listen to both sides' arguments. So I think that's why the bigger issue for us is at some point we're hoping that videotape will be released and the public will be able to see just how fair the proceedings in this case have been all along. And with that, I think we're ready to answer some questions.
The floor is now open for questions. If you do have a question, please press the number 7 or the letter Q on your telephone keypad. Questions will be taken in the order they are received. If at any point your question has been answered, you may press 7 or Q again to disable your request. If you are using a speakerphone, we ask that while posing your question, you pick up your handset to provide favorable sound quality. The first question comes from Lisa Leff of the Associated Press. Lisa?
So what other options or what options did Judge Ware have for dealing with this motion besides scheduling a hearing?
Ted Biltris, go ahead.
Lisa, I'm not sure. You said what other options does he have for dealing with this motion? I'm sorry.
Yes, that's right. Did he have any other options? Was the hearing necessary to deal with this motion?
I think in this kind of situation, even though the motion is so frivolous, judges, in my experience, often do want to bring the parties in, clear the air. These proponents falsely are claiming that they've been treated unfairly. So this is the kind of approach I've seen many judges take in cases like this, even where the motion is absolutely baseless. Let the proponents be heard. Let's see them stand up in open court and see this. I'm looking forward to that. I want to see what they say when they're standing in the court and they have to defend their position. And so I was not surprised at all that the judge decided to have a hearing.
I think that this is Ted Olson. I just add that I'm hoping that the judge was interested in having the opportunity to say, and will say to counsel for our opponents, what did you know and when did you know it? What did you know and when did you know it, so that they can answer the question about why they decided to pop up with this thing at this late a date.
And this is Chad. One thing I'll add to that, and I know some of you have actually alluded to this in some of the stories that have been written. I know at least 2 of the major newspapers have. When the trial, prior to the trial ever beginning, reporters and everyone knew that the judge was gay. In fact, many of you very specifically and directly asked the proponents if they were going to raise that issue. And they told you, whether on the record or off the record, that they were not. That was obviously prior to their having lost the case. And many, many months after the decision in the case, they obviously changed their mind.
Thank you.
The next question comes from Lisa Keene of Keene News Service. Lisa?
Thank you. I was wondering, I think from what you're saying, I have the presumption that you felt pretty comfortable that you knew Judge Walker was gay, if not openly so, that he was gay, and that you weren't troubled by his ability to, render a fair and neutral opinion on it. But I wonder if it ever occurred to you that this argument might be made that he had something to stand to gain if he ruled that Proposition 8 was unconstitutional.
This is Ted Olson. We had heard people report what they thought was the judge's sexual orientation. It was uniformly agreed on our side that this is an experienced, highly respected federal judge, the chief judge of the district court there in San Francisco, and he has a record and a reputation of being fiercely independent, calling them as he sees them, and we were entirely comfortable, and I would be again and again, with expecting the judge to do the kind of job he did, which was to give our opponents and us every opportunity to put on whatever witnesses, whatever evidence. He listened carefully, he ruled thoughtfully, he called some motions for us, and he called some motions against us. As to whether he might have something to gain, everybody in California would have something to gain, we argued, by getting rid of a badge of discrimination out of the California Constitution. Our opponents were saying the people that had things at stake in this case were heterosexuals whose marriage would be somehow diminished, and therefore I suppose you could make the argument that a heterosexual judge ought to be disqualified. But no, we did not consider at any time urging his disqualification or urging anything else. We respect federal judges, especially federal judges who have the stellar reputation that Judge Walker had.
Thank you.
We have another question on the line from Lisa Leff. Lisa?
Hi again. So I'm trying to figure out whether or not any of you can recall any other times a judge's sexual orientation has been cited officially to challenge a ruling. I know it's come up on occasion in terms of confirmation hearings. In most recent, I believe it was in Massachusetts, the Supreme Court there. But are you aware of any other times it's come up directly involving a ruling?
I'll answer first, and then I think Ted might have something to add. I don't know of any. I do know that it was raised in various different contexts with respect to judges, with respect to race, and whether judges who maybe were African Americans could consider cases involving racial discrimination, and the questions similar to that have been raised with respect to women. Could they handle gender discrimination cases? Should they handle pregnancy discrimination cases? It's been thought up. It's been raised with respect to jurors, and in fact, courts have held it's unconstitutional to take a juror's race or gender into background in connection with attempting to disqualify a member of a jury. But I do not specifically know a case involving sexual orientation in this context.
And I don't either. We as we researched these issues, we did not find any other examples, which I think again goes to a couple of things. One, that gay men and lesbians, that the laws, there have not been as many cases like this, and
right.
The fight for equality is at an earlier stage. It's sort of the last discriminatory laws on the books against a particular group. But also, I think it goes to the over-the-top, outside the mainstream proponents of Proposition 8 that are in this case. They've now shown they'll basically stop at nothing to try to defeat the rights of gay people, and I think it's just another point that supports that notion.
Yeah, and I would just add to that too. I mean, a few of you in calls prior to this conference call has asked, if we were surprised. And I think surprised, yes, in the sense that these lawyers and legal counsel would bring such a frivolous motion. But I've reminded some of you have written, but that the opponents are very specific people who hold very specific views. Gail Knight, William Tam, Dennis Hollingworth. Those are the proponents of Prop 8. Those are the people who put Prop 8 on the ballot. Those are the people who led the campaign in the way that you saw the campaign was led on Protect Our Children. And so I think if you really look at who the other side is, you probably are less surprised that they would bring something like this after losing. And I do think it's important when we talk about both sides of this case and who those that brought the case, our plaintiffs, and then those who filed a motion to intervene and are on the other side. They are very specific people who hold very particular views about gay and lesbian people. And I know many of you have written profiles of those individuals, but I think if you look at those people, William Tam, Dennis Hollingsworth, Gail Knight, and a couple of others, they're the ones that put Prop 8 on the ballot. They're the ones that filed to intervene in the case. In fact, they're the ones that the California Supreme Court will look at them and people like them, whether they have standing in such cases on appeal. So I do think it's important to keep in mind the political and personal views and animus that those individuals have towards gay and lesbian people, and have very publicly held those views all the way back to the days of Prop 22.
Thank you.
Again, if you do have a question, please press the number 7 or the letter Q on your telephone keypad. We do have another question on the line from Lisa Keene. Lisa?
Yeah, thank you very much. I'm glad that the two Lisas are the ones getting to jump in here. It's great. Thank you for the time. Quickly, Ted Olson, could you please explain again why you won't be in the courtroom on Monday? And is Ted Boutros, are you doing both the argument for the motion to vacate and the videotapes?
Yes, this is Ted Boutros. I'll let Ted Olson jump back in.
Okay.
The reason I'm not there, and I'd really love to be there, is that the United States Court of Appeals for the Second Circuit in New York, in a very major copyright case, has scheduled an argument, and it's linked to another case. So there are two cases scheduled. It's not the same day, but it's scheduled such that I couldn't properly represent the clients that I've represented for quite some time in this copyright case. And Ted Boutros has been present during every moment of the Proposition 8 preparation and the trial and the appeals. In fact, he handled several of the witnesses and handled a good number of the motions and a couple of the appeals already. So I think David Boies and I, neither one of us could be there in California, but we feel that Ted Boutros and David and I are pretty much interchangeable, so Ted will be handling it.
Okay, thank you.
The next question comes from Josh Bennett of NPR. Josh?
Hi, just had a quick question. Do you expect an immediate ruling on this motion after you make your arguments on Monday, or is this something that's going to be a delayed response?
Go ahead, Ted.
Hi, Josh. With federal judges, you never know. The judge could just rule right there, or could say, I want to think about it. And again, I think in these circumstances, different judges handle it differently. He's giving them a hearing, letting them air their frivolous arguments, and so it could be that he just decides right then, or says that he'll issue an order. So we just don't know.
Okay, thanks.
We have another question on the line from Lisa Leff. Lisa?
Hi, I'd like to get your thoughts on the argument that has been advanced by at least a couple legal scholars who wouldn't be described as conservative, that it would have been advantageous. Obviously Judge Walker had no obligation to recuse himself. It would have been advantageous if he had brought this up at the beginning of the trial, sometime during the trial, kind of, as you said, clear the air.
This is Ted Olson. I think that would be set an awfully dangerous precedent. what would a judge do who was a Mormon, knowing that the Mormon Church took such an active role in this case? What would a judge who had a nephew or niece or son or daughter who was gay or lesbian, what would a judge do who was hoping to have children, who was asked to consider a case involving the Federal Pregnancy Disability Act? We have an unlimited number of permutations of what a judge might be asked to disclose. We have very specific limited circumstances where disclosures are required, and we put the bar reasonably high because every person alive has some background and experience that might conceivably, arguably, if lawyers are going to set their principles aside and raise them, could conceivably affect their attitude in a case. And I think it would be actually affirmatively a dangerous pattern for a gay judge to have to say, well, I can't handle marriage cases, or I can't handle adoption cases, or I can't handle divorce cases. I think it would be a very dangerous precedent, and with all due respect to the people who have raised that, I don't think they've thought it all the way through.
Thanks, Ted.
Again, if you do have a question, please press the number 7 or the letter Q on your telephone keypad. Please hold while we wait for the next question.
If there are no more questions and no more leases on this call, I know there are about 20, there are 20 some odd ones of you on the call, and you've talked to many of us prior to this call, and I know several of you have things scheduled post-call. But are there any other calls while we've got particularly Ted Olson on the phone this morning? Otherwise, we'll end the call and work with those of you who are working on stories for the weekend or on Monday and get you access to whomever you need. Are there any more questions for this call?
And there are no questions in the queue at this time.
Okay. Well, thank you, everyone, and I just want to remind everyone to, if you haven't seen already, the tribute video to the Loving v. Virginia decision, whose anniversary is this Sunday. AFER released a video that some of you have written about and has had wide viral reach in the last 24 hours, and all of you got the press release and eloquent op-ed piece written by Julian Vaughn of the NAACP, as well as the video with Ted and David and the story of Loving. So with that, we'll end the call and look forward to seeing many of you in the courtroom on Monday, and call the office at AFER directly if you need access to anyone on the team as you work on your stories. Thanks, Ted and Ted, for your time, and look forward to seeing everyone on Monday.
Bye-bye. Thanks.
Thank you.
That concludes today's teleconference. You may now disconnect.